All right, we're going to go ahead and get started. Hello, everyone. My name is Theodore Russell. I'll be moderating the second panel. I am the Administrative Director of the Institute for Compliance, Risk Management, and Financial Integrity here at Case Western Reserve University. So I hope you all enjoyed lunch, and we'll get started right away. So the first speaker that I would like to introduce is Professor Eric Chafee. Eric Chafee is an expert in and teaches courses related to business law, contract law, law technology, and taxation. Over the course of his career, he has received numerous awards for his teaching. As a writer, Professor Chafee focuses on business law, emphasizing compliance, cybersecurity, securities regulation, taxation, and business ethics. He's an author of a leading treatise on securities regulation in cyberspace, with work that's been accepted for publication in numerous law reviews, such as Boston College Law Review, Ohio State Law Journal, UC Davis Law Review, and Washington and Lee Law Review. He's published many articles in specialty journals at institutions like Stanford, New York University School of Law, University of Pennsylvania Law School, University of Michigan Law School, and he's regularly invited to speak at symposia, conferences, workshops, and other events across the United States. He's actively involved in various legal professional organizations, such as the American Law Institute and a fellow at the American Bar Foundation. Currently serving as chair of the American Association of Law Schools section on Internet and Computer Law and chair-elect of the section of Business Associations. He's also served as chair of the section of Securities Regulation and chair of the section on scholarship of that institution as well. He's a co-founder of the National Business Law Scholars Conference, which is the leading business law academic conference in the United States. He also currently sits on the executive committee of that organization. So with no further ado, Professor Chafee.
Thanks, Theo. So the topic of this panel basically is artificial intelligence and financial advice with focus on robo-advisors. Certainly when we put this together, both Nicole and Ben, who will be speaking virtually in a couple of minutes, the people we wanted for this, in addition to that, Andrea Site, who's Commissioner of Securities in Ohio, has an excellent piece on this in the Toledo Law Review from a symposium that I hosted a few years ago that I refer to on a regular basis. So I recommend her work as well. So in terms of my presentation, I'm going to talk about securities regulation and artificial intelligence, regulating robo-advisors. To get this out of the way, I'm going to to advance. I'm not a robot. Despite the fact that apparently you can actually now train a robot to check that box, I do actually attest to that, although Jake's statements about how people think and the fact that artificial intelligence is not there, I'm not sure that I'm that far off like he's actually attributing to conscious thought. So what I'm going to talk about, I'm going to talk a little bit about what is a robo-advisor, the emergence of the robo-advisor industry, regulatory models for it, meaning to provide some foundational information on exactly how robo-advisors can be regulated and how they should be regulated. And then talk about my suggestion in the space, which is what I term regulation by survey and the case both for and against that. So a lot of this is animated by a conference that I was invited a few years ago to by my friend Ernest Lim at National Singapore University and my friend Philip Morgan at York University. I actually thought that there was going to be a trip to Singapore that I would get out of it. COVID happened. And then suddenly, rather than speaking in Singapore, I was speaking in my office at 4 in the morning. Still a lovely conference. I thought about putting a picture of that, but it was just too sad. So we left with that. In addition to that, I also edit that treatise that Gia mentioned. So if you're looking for more information about this, there is some additional information there. But the first question that we need to address, what is a robo-advisor? Which actually is more complicated than you might think. There are a bunch of different definitions out there. It's certainly not the automatons that you see in the television show Westworld, or pick your other favorite sci-fi franchise, be it, I don't know, the Cylons from Battlestar Galactica or Mr. Data from Star Trek. It's not even the 1970s version of Westworld, which surprisingly enough starred Yul Brynner and was less technologically advanced than the current version. The definition that I like basically is this one. Meaning that essentially a robo-advisor is a client-facing computerized investment tool that provides financial advice or assists in investment management. Notably, that's developed from a definition that FINRA put together in terms of some of its materials, one of the financial regulators of the securities market. I like the fact that it emphasizes that robo-advisors are tools, meaning that they are much closer to the calculators that you see on your computer than Mr. Data or C3PO. In addition to that, obviously, the fact that they're computerized is important. We're not talking about abacuses, abaci, I'm never sure what the plural is there. We're talking about things that actually exist within computerized environments, algorithms. They're client-facing, meaning that a lot of robo-advisors are in fact the same tools that if you have an investment advisor who is human, will actually use in providing you with investment advice. That's also important because we're not talking about quant firms, high frequency trading firms. We're talking about things that the average retail investor can access for purposes of actually making investment decisions. Then finally, what I think is probably the most controversial part of this definition provides financial advice or assists in investment management. I don't know that that necessarily gets you that far beyond the computer on your, or the calculator that you have on your standard computer, but close enough for government work. So we'll go with that. The next question that comes out of that essentially is what sort of regulatory models are available. And I list 7 of them on the screen. I'll talk a little bit about all of them. In terms of thinking about agency law, which is a nice place to start, people want to use this, but you shouldn't. Meaning that, I was at a conference recently, somebody was talking about regulating broker-dealers and artificial intelligence, and they suggested that agency law would be the ideal means of doing that. My initial question was, well, how would that work? In terms of thinking about agency law, despite the fact with artificial intelligence that we might get there eventually, we're not there yet. What I mean by that is that in terms of thinking about agency law, you see a definition of agency relationship from section 101 of the restatement of the law third of agency. It requires consent, and artificial intelligence, it's not there yet. Potentially we could create some sort of artificial consent model the way that we have for corporations and other sorts of non-human devices, entities. But there's really not a point to do that yet at this point. We may get there, but we're not there yet. Second option, design intervention. What I mean by that is that regulators actually could make conscious choices and demand that developers make certain sorts of modifications to code to allow or not allow certain types of behavior. For example, regulators can mandate that if you're an investment advisor and also a broker dealer, that you never can actually recommend securities that you will actually be selling, that sort of thing. I don't like that because I don't think we know exactly what we have yet with artificial intelligence. One of the things that I'll say is every time that I hear people like Jake and Betsy speak, I think here's a new and wonderful way that we might use artificial intelligence that I hadn't thought about yet. And I think design and intervention is dangerous for that purpose. Merit regulation, I like the fact that Ohio has merit-based regulation. I sleep a lot better because the Ohio Division of Securities does their job very well, but it's not perfect either. There was a startup computer company in the 80s that basically wanted to sell their securities in Massachusetts. The regulators in Massachusetts, who in general are very good at their job, said, no, this is too speculative, this will probably never fly, and who knows what happened to Apple computers anyway. So, as a result of that, with merit-based regulation, because this is a very sophisticated space, ultimately, securities regulators know a lot about securities markets and products and the people involved within the securities industry. I have some hesitancy as to whether or not they're in the right place in order to engage in merit regulation, despite the fact that I think merit regulators in Ohio do a great disclosure-based regulation, that's our current system of federal securities law, which I really like. One of my favorite quotes from Justice Arthur Goldberg is on the screen. The fundamental purpose of federal securities law was to substitute a philosophy of full disclosure for the philosophy of caveat emptor to achieve a high standard of business ethics in the securities industry. Disclose a lot of information. If people want to do things, let them do them, even if they're ethically dumb. If they want to buy hot garbage in terms of their securities, they can do that. I think probably with regulating robo-advisors, that makes a lot of sense. And we've seen SEC guidance, we've seen NASA guidance, the North American Association of Securities Administrators. It's been really good about what should be disclosed and what's required to be disclosed. And certainly, robo-advisor platforms are subject to federal securities law. You have a provision here, Section 202A11 of the Investment Advisors Act of 1940. These platforms are not fighting this. They actually want to be investment advisors because it helps them to have legitimacy. And as a result, they are subject to the disclosure requirements of federal securities law. Relatedly, they're also subject to the fiduciary duties that you see in that space as well. Things like suitability, loyalty, care, all of those things that go along with a robust system of fiduciary duties. I have mixed feelings about that. I think it's great for investor protection. I wonder if those are a little bit high. The reason as somebody who's a fan of investor protection that I think that they might be a little bit high is one of the things that I genuinely like about robo-advisors is they provide financial services to segments of investors who might not otherwise be able to afford it. Fiduciary duties, we're going to need to figure all of that out. There have been some great pieces written on it, but I don't know that they've quite gotten there yet. But I do like the fact that they're being used in this space. There's investor education, which I like as well, because I'm in the education industry. We do have some financial literacy problems in the United States. There's an excellent piece that was written by Lisa Fairfax at Penn Law School a couple of years ago about really the challenges that we're facing. But I do think that educating investors about this particular technology is important. And then finally, there's what I term regulation by litigation, meaning that you have things like Section 10B and Rule 10b-5, you have things like the fiduciary duties under the Investment Advisors Act, and you let the law evolve slowly over time, grow actually with the technology itself. Definitely some positives to that. At the same time, you do have some concerns as well in terms of whether or not it'll grow in the correct ways, whether or not there ends up with judicial overreach in that space, and then finally, it does tend to happen after the fact, meaning you need to have a lot of problems before regulation by litigation actually pops up. In terms of thinking about that, it's really those final four that we have listed on the board that are our current system of regulating robo-advisors. Actually, I'm pretty comfortable with that. That being said, one of the things that I spend a lot of my time doing is thinking about our current system of regulation and whether or not it's a good fit for the realities of today. And ultimately, in regard to the 1930s, great system of securities law created, in my estimation, in the sense that it's kept United States securities markets safe, secure, and strong. But 1930s was a very different time than today. And one of the things that has struck me is that with new technologies, there's become surveillance issues, or there's come along with them surveillance issues of certain markets. And the question is what we could be doing better. In terms of answering that, one of the things that I've spent a lot of time thinking about is what I term to be regulation by survey. And what I mean by that, regulation by survey, is the surveying by regulators of investors for purposes of understanding market behavior and detecting wrongdoing. So the idea is that because we have the internet, we have email and that sort of thing, we actually could be talking more to investors to figure out things like what they actually find to be, who exactly they are, how they're behaving, how they're being treated by certain industry professionals, and that giving basically regulators the opportunity to do that, seeing whether or not it's effective is something that would be a very useful thing to do. I have a piece in the Boston College Law Review. I talk about this in regard to robo-advisors. I talk about it in regard to crowdfunding, in regard to virtual space. There are certain places where I think this would be really useful. First off, because the securities law hasn't ossified there, meaning it's not hardened yet. There are new technologies. Second, in addition to that, with robo-advisors, for example, the lack of intermediation means that things can go wrong and things can go wrong quickly, and you can have real tragedies prior to the problem being detected. Certainly, in terms of thinking about that, my idea would be to have some general questions, so some questions on the board from a release from NASA a couple years ago on robo-advisors, and then in addition to that, some numeric scores. The reason is that it would give regulators the ability to know what's occurring with robo-advisors, but also would give some ability on the part of investors to compare robo-advisors based on the scores given. Ultimately, in terms of thinking about the arguments for this, I do think that it would improve market surveillance and understanding. We would get new data that, in fact, would be interesting. It would be interesting to know who uses robo-advisors, how they're using them, and why they're using them. It would promote market confidence, meaning that for better or worse, consumer surveys, when they're released to the public, they make people more comfortable with certain products, and they often dissuade them from products that they shouldn't be using. So, as a result of that, I do think that federal securities laws and securities laws generally are about creating strong markets. Part of how you do that is you convince people to invest, and you keep convincing them to hold investments for longer periods of time. And I think that this would be part of that. I also think that for better or worse, this would also improve investor decision making, because investors, despite the fact that they sometimes lack financial literacy, that they do internalize investor review, or they do internalize basically online reviews of things. For example, if I'm looking for a restaurant in any town, one of the first things I do is figure out which ones are highly scored, and I pick that particular restaurant. And usually it has good results. Certainly there are concerns. With regulation by survey, you will end up detecting things after the fact, meaning that ultimately harms may have occurred. My answer to that is that this just isn't all about that. It's about actually understanding markets. Beyond that, fraudsters are going to fraud. So as a result of that, catching a fraudster at some point means that they're probably not going to continue to do fraud in the future. And it's better to punish somebody rather than not catch them at all. Beyond that, we also have those other four things that I mentioned in terms of regulating in this space. Concerns about depending on investors to provide meaningful information, meaning that, as Commissioner Sipe will tell you, sometimes investors do not know that they've been taken and will actually get mad at regulators because they think the regulator is keeping them from their money. So as a result of that, with regulation by survey, you do have the risk that people will not always realize that they are being treated poorly. Red flags will pop up. For example, if you contact tech support and they're not willing to talk to you or never get back to you, that's one reason why you might have a regulator knocking on the door of the robo-advisor platform, the investment advisor providing the platform. In addition to that, you also have trolling and manipulation, which is part of the reason why I want the regulators actually to conduct this surveying, because they'll create better survey instruments. Second, in addition to that, they should have the power to go through the information and decide whether or not it should be released to the public. We do have access to capital issues in the United States where certain groups have trouble getting access to capital for reasons that they really shouldn't. If you're finding you're getting a lot of things through the survey that are using, I don't know, improper types of slurs, that sort of thing, certainly the regulator would not want to release that. But trolling manipulation is a concern. And you do have things like Section 10B and Rule 10b-5 that can help to mitigate that, but may be a problem. And finally, last but not least, costs, meaning that the SEC does have some economists on staff who are supposed to be surveying the market that could help with all of this, but it's certainly not going to be free. Notably, in regard to that, my position on this, despite the fact that I've talked about it quite a bit, I'm not sure it's a great idea. Meaning that it's one of those things that I think is worth trying, but I'm not sure ultimately if it should be implemented in all places. And certainly, having a pilot area such as robo advisors, I think would be a really good thing, meaning that ultimately seeing how the costs play out in that role in that area would be really important. Maybe it's worth it, maybe it's not. In addition to that, we could see what we get, and as a result of that, we might be able to roll back disclosure in other places or rethink disclosure in other places and cut back on the costs of costs on issuers and other industry participants in other places. So I think I'll leave it there. Thanks for listening, and look forward to questions again.
Thank you, Professor JP. So let's hear your questions. And also, if there are any questions online, then Rob, if you could please read those out, that would be great. Yes.
So this question came up both in response to the last presentation last time and also as we were chatting over lunch, and I think it's raised by your presentation too. When we think about fiduciaries and we think about the duties of advisors, some of whom are fiduciaries, is a machine capable of carrying out a fiduciary duty? Or is it just that a robo-advisor can't possibly be a fiduciary?
So the investment advisors that actually provide these tools, I think, are the ones with the fiduciary duties. Will we get there? Will we have AI that's sophisticated enough that we might be able to charge them with fiduciary duties? Maybe. At that point, we probably want to make sure that there's some sort of pool of assets or insurance that they have that they can pay judgments based on that. But my view is that these really are tools. I wish that smart AI exists because I love science fiction and I think it would be fascinating to see what it does. But it's dumb at this point. Our smart AI, even the smartest, is still dumb. So, but it's a great point. It's one of those things also where there's a secondary issue of when you're intermediating basically advice through an AI, whether or not you can ever meet your fiduciary duties as well at that point. And that's really complex. There's been a lot of people struggle with that. And I still have, I'm still working on that.
Thank you. Next question. Yes.
Thank you. So Eric, do you have a template for the survey you would like to see regulators to do in order to assess the effective or performance or maybe issues and complaints regarding robo-advisors?
Not yet. Meaning,
All right.
I'm getting there. So if you know any regulators who are interested,
I happen to know, I'm really fascinated by that idea. I do think regulators do not interact with investors enough. And we certainly regulate and make assumptions about what their needs and wants are. But we don't really, test or validate that. So I really like that idea. I do think that, regulators do have access to data for DIY platforms, robo-advisors, could find, they could identify a population of investors who leave that service model. It would be interesting to know why they're doing that. Those who stay in it for the long haul. So really fascinated by that work. If you do develop one, please do share.
I think I know what I'm doing this summer, and I definitely will circle back.
Thank you. Other questions? Okay. Great. Well, thank you, Professor Chafee. All right. Next, we are turning to Professor Nicole Iannarone. Nicole G. Iannarone's scholarship focuses on Main Street investors. She studies regular investors' disputes with professional services providers, exploring the intersection between professional regulation, dispute resolution systems, transparency, and technology. Her work has uncovered barriers that investors face in entrenched mandatory arbitration forums and recommends interventions to increase consumers' investors' access to justice. Professor Ayanna Roan's Investor Justice Scholarship has appeared in or is forthcoming in Minnesota Law Review, University of Pennsylvania Journal of Business Law, Washington Law Review, and Cardozo Law Review, as well as other leading law journals. She is frequently asked to share her expertise with regulatory and policy-making bodies, as she has often testified before the U.S. Securities and Exchange Commission and the International Association of Securities Commissioners on issues related to retail investor protection. In 2024, she presented the keynote lecture at the SEC's Securities Arbitration Clinic Summit. Her teaching includes courses in civil procedure, business organizations, securities regulation, investor protection, business arbitration, and professional responsibility, subject areas directly related to her scholarship and extensive practice background. Professor Ayanna Roan is involved in national level engagement in communities related to her scholarly focus. She is the immediate past chair of the Financial Industry Regulatory Authority National Arbitration and Mediation Committee, the advisory group responsible for studying the FINRA Mandatory Securities Dispute Resolution Forum and recommending changes to FINRA's Board of Governors. She's a public member of the Certified Financial Planner Board of Standards and Public Policy Council. Professor Ayanna Roan is active in the American Association of Law Schools, including by serving as incoming chair of the Securities Regulation Section, a former chair of the Employee Benefits and Executive Compensation Section, and her current member of the board of the Business Association Section and the Provisional Race and Private Law Section. Before entering academia, Professor Ayanna Roan was a partner in a business litigation boutique. She is a former president of the Atlanta Bar Association and the Atlanta Council of Younger Lawyers. She has chaired the State Bar of Georgia's Professionalism Committee, Atlanta Bar Association's Reputation and Public Trust Committee, and served as a liaison to the Georgia Chief Justice Commission on Professionalism, among her other leadership roles. Professor Ayanna Roan received her JD from Yale Law School, where she served on the Yale Journal of Regulation and Executive Committee of the Latinx Law Student Association. She graduated summa cum laude with high honors in liberal studies from Ben Rao Women's College. Thank you very much, Professor Ayanna Roan, for joining us.
Thank you. Thank you to the Journal for having us and putting together a panel on robo-advisors. And I want to thank Eric for really bringing the band back together, because Eric and Ben and I have been thinking about robo-advisors for about 10 years. So this was worth my 5-hour flight delay yesterday, and I'm sorry I missed you at dinner. I want to pick up where Eric left off, and that's talking about models of regulation for robo-advisors in particular. I'm going to talk a little bit about regulation by survey, but really where I think we should be looking at regulation for robo-advisors are in those last 4 highlighted areas when Eric gave us the frameworks for regulation. And that is disclosure, fiduciary duty, education, and, well, some regulation by litigation. I think a lot about what happens to regular people when they invest. And one of the things that initially attracted me to robo-advisors is this. It's really expensive to get a financial advisor if you don't have enough money in their minds, right? How is a financial advisor paid? There's lots of different frameworks. I'm going to stay in the investment advisor framework. They're paid typically by a percentage of the amount of assets that you have. And of course, every advisor wants to make sure they get the highest compensation they can. That means that most of us regular people can't get a human to help us out, because they look at our account and they might say, you know, for this fiduciary level obligation that I owe to you, what I would make off this account isn't worth it to me to help you. So technology really assists in building capacity for regular people to get advice, and frankly, it brings down the fees quite significantly. So we're seeing much smaller, like 0.5% of assets under management as a fee for a robo-advisor. Now, I can sort of start at the education level, and I'm going to begin with something that's a little bit of a pet peeve of mine. What do we tell investors? What do we tell them about how to protect themselves? Well, we say, get educated. Don't buy or invest in anything that you don't understand. That's great advice. We shouldn't buy things that we don't understand. But I'm going to tell you why it's also my pet peeve. Why do we have to understand the transaction? There are lots of things that I don't understand. I don't understand how pressing a button and turning this microphone on means that all of you can hear me and that Ben on the Zoom can also participate, hey Ben, in this entire conversation. What I do know is that I have a goal, and my goal is that I want the room and Ben to be able to hear, and that by pressing a button, it happens somehow by magic. And we can come up with all sorts of examples where we have some action that causes a result. We don't really care about what happens on the in-between. Now, you'd probably say right now, and I mean, especially if you're a securities regulator like Andrea, you're looking to be like, of course we want people to understand about this. There's something different about your finances than there is about speaking and being heard in a larger room. It's much more complicated, isn't it? To make sure that we are on the right path for retirement, for saving for a house, for whatever our financial goals are. But, you know, it usually works. Maybe we're really only worried when there's a problem. And so I sort of start with the framework that came up in our last question about fiduciaries as advisors. And I always appreciate when folks like Eric use the proper terminology. When you see an E in advisor as opposed to an O, that's a regulatory term in the Investment Advisors Act. An individual who is an investment advisor with an E owes fiduciary duties to their clients under the 1940 Act. And the way I see technology in this is there's always a person, at least for now. We don't have any, to my knowledge, investment advisors that are operating as DAOs and claim to have not a single person involved anywhere. So someone is always in charge of ensuring that the fiduciary standard is met. Now, I am so glad that my flight got here and I didn't have to deliver this from home, because this is one of those talks where I talk about my husband a little bit. And I talk about him because he's sophisticated in his own business, which is not law. And he had a business transaction a few years ago, handed me all the paperwork for it and said, here, can I sign this? And I said, well, that's not what I do as a lawyer. And if you're asking me as a lawyer, that means I'm your fiduciary. I need to tell you about the problems, the harms that could arise. So let me make sure that you understand what is going on with this document before you sign it. To which his response was, why do I have to understand? Isn't that why I'm hiring an advisor? And I have to admit, he has a point, and a particularly good one in this area. Why does the investor need to understand the investment that is being recommended to them when we have a fiduciary standard and the person proposing that investment has obligations to ensure that it's in the customer's best interest, that it's suitable, and that the recommendation is being made without a conflict of interest? I think that's too much of a burden and a responsibility to place on an investor. And I prefer to focus on the fiduciary and hold them to their promise. Their promise is, I am here to advise you. And as long as we get the result that we want, we push the button, the microphone works, great. Our robo-advisor can help us increase our balances, and all is fine. I worry about when the result doesn't come out the way we want. Eric's definition of robo-advisor, which is one that I've also adopted, we have a tool, a computer involved. Well, you know, when things go wrong, we want a person, don't we? When my flight was delayed yesterday, we kept getting information that we didn't keep getting information. We kept getting push notices on our phone that your flight's gonna leave in 15 minutes. Don't leave the gate. You're leaving in 15 minutes. That went on for 5 hours. And you can imagine what's happening at the gate. When an agent comes up to the gate, an actual person, and makes an announcement, people who are standing around the gate start screaming out questions. Wait, you just said we're waiting on maintenance. What does that mean? Does that mean we're waiting for a person to fix it? Does that mean that they are fixing it? Does that mean that we don't have a part? Give us some more explanation. I tried to use the airline's chatbot to change my flight because I saw a later one that looked like it was probably going to actually leave. And my phone says you should be able to change your flight on your own until I press all the buttons, and it won't because I've checked into another flight. It took me 30 minutes to get to a person. By that time, on the chatbot, after explaining my problem, they're saying, no, we can help. I want a representative. No, we really can help. Are you sure? Yes, I definitely want a representative because I've tried all of the prompts that you have suggested and none of them are solving my problem. Lots of frustration. There were a lot of angry people around the gate. A lot of time was used to get to a pretty simple question. Is there another flight you can put me on that gets me to where I want to be? Is because I'm looking at Ben on the screen, I think about another technological tool that has some of those issues. Ben lives in Las Vegas. And have you all heard about Waymo? Driverless cars?
Yep.
Well, Google sometime what happened in Las Vegas at the airport with a Waymo. Great idea if you can get into a car, it takes you A to B, and you don't even have to talk to a human to do it. This car in Vegas just started going in circles at the airport, and they couldn't find anybody to help and really make it stop. So I worry about when things go wrong. How do we deal with this? And truly, to the very good question that Professor Rosenblatt, I think, asked, is a computer, can they be a fiduciary? And I've been thinking about this for about 10 years. Can a computer be a confidant? Can they be someone who really meets with us where we are and helps us understand how to get to our goals, answers our questions, is there at all of the times that we need them? And I don't think they're there yet. We still need humans to help out, even though the technology is getting better. The SEC has, I think just yesterday actually, had an entire roundtable on predictive AI in the financial industry. And we have commissioners coming at it from very different angles. Commissioner Kerr saying, we really shouldn't be scared about predictive AI and how it fits in, and we should embrace these new challenges and potential new regulation. Commissioner Crenshaw on the other side says, let's think about what we need and the possibilities for growth. And I'd like to think that I've taken Commissioner Kerr's call to heart. I don't always agree with her on things, but I do agree we need to not be afraid about the technology and think about how it can advance us and where we're going next. I've been learning a little bit about AI and pursuing my own graduate coursework in computer science and data science in all of my spare time. And as someone who has went to law school because they promised there'd be no math, never took calculus in my life, and have not taken a single math class since 1994, it was really hard when we had to learn the calculus to build our own AI models. The thing is, I made it through, and I recommend that all of you try it too. You can do this. It's totally doable. But I used resources to help me. I didn't know what a derivative was. I've heard that word. I needed to have something help. ChatGPT did a great job. And I said, I don't really understand this chain rule. This is what I think it means. Can you help me? Can you build a problem for me so I can test my knowledge and understanding of it? And in that sense, it was giving me some disclosure. It was helping me understand something that I didn't know. Why can't we leverage those capabilities to help out in our regulatory schemes? I said I was going to focus in on, we've talked a little bit about fiduciaries. I want to layer in disclosure with that. Disclosure is the main way we regulate in the securities realm. And why does it have to be an upfront disclosure? one size fits all for everybody. Here are the risks, here are the benefits. Are you sure you want in? So I thought about that a lot because honestly, most of us aren't going to be able to understand the disclosure. Even with a law degree, the disclosure that we get in the securities industry is incredibly dense. There's a lot of words. And if we're looking to increase access, particularly in a world where most Americans lack significant financial understanding or other literacy, maybe we can do better, deploy the tools that are mostly used by others to make money to help out that particular group and all of us. Why don't we have something that learns from our actions, our engagement with the technology, and builds disclosure in an active and iterative way? I like to think about this idea, which I had before ChatGPT existed, so it's an even better idea now. That there's a lot of data everywhere. Data's the new oil, right? And if every time I'm engaging with my robo-advisor, I'm creating data. As a user, what am I doing? Have I said that I am a very I have a high risk appetite and I'm willing to lose everything, but the computer and the robo-advisor sees that I log into my account every hour? Maybe it should then ask me, what I'm seeing based on your usage patterns is that perhaps what you have said about your risk tolerance is incorrect. We have the data, we can, particularly as the technology goes forward, think about ways to bring it in to improve disclosure. Now, there's a lot of issues with a iterative, continuous, active type of disclosure, and that is, how in the world is the SEC supposed to look at it? How are the regulators supposed to look at it when every single person in this room gets advice written in some other language? Just like when I was using ChatGPT to help teach myself calculus, sometimes I'd have to say, can you explain step 3 again and make it even easier? And I did that, and I still didn't get it. Say, I need even easier than that. Break it down even more. Assume I'm kind of smart, but I know nothing about math whatsoever. That generates an awful lot of work for our regulators, and I don't know how to solve that particular problem, how we look at it. Maybe we provide safe harbors. You're trying really hard, and you didn't get it quite right, but okay, we've taken a look, we see the issue, we'll fix it now. So I can't answer all of the questions related to this, but I like the idea simply because, in addition to having thought of it, the data exists. It will also help us build, I think, more of a connected relationship between regulators and the providers of the technology. Eric was talking about playing together more. I think about that as sandboxes, giving the regulators the ability to come in, have an interactive sandbox with the regulated entities to just take a look at what's happening with a random customer at this point in time. And of course, that wouldn't prohibit the ability of the regulators to come in after the fact to look more broadly, or if something goes wrong. I'm going to end because I can't remember what time I started, but I think I'm nearing my end. I want to tie this, and 3 minutes, perfect. I want to tie this into our core responsibilities as lawyers as well. As lawyers, when we think about, we're fiduciaries, right? And we're kind of the prototype of what a fiduciary is. So we don't apply it the same way in the financial services world. I want to think about what our ethical duties are to our clients. And one of those is to be competent. And I'm certain by now this is no longer a new amendment to the Model Rules of Professional Conduct. Rule 1.1 says all lawyers must be competent. And there's a comment in there that says, competence involves knowing about the benefits and risks of securities and technology, and communicating those risks with your clients. So I think that means that all of us in advising clients, working with them, really need to get into that space more, understand this technology. I also think about lawyer ethics and how we talk about disclosure. Would we have a conflict of interest when we're asking a client to do something that's a little bit different? We have to explain in a way that our client understands. Go to a place to reach them. The securities laws are not written that way. We have to have a disclosure that's purportedly written in plain English, but I will tell you it is not the English that you or I speak when you see those particular disclosures. So we can learn a bit from the lawyers. And I'll end really, really quickly with this. Please get some tech expertise. Learn how the tools that you are using in your day-to-day lives work. It's hard, it's worth it, and our brains stay plastic and strong by flexing them in this way. And I know many of you went to law school too because you didn't want to do any math, but I promise it is doable. And building that capacity shouldn't just be with us and the lawyers. I also hope to have that capacity in the regulatory authorities as well. One of the things that I loved our keynote speech earlier today, but what I particularly loved about it is how it's the first time I've really seen someone with a technical background talk lawyer, right? We talk lawyer, scientists and data science and computer science folks talk science. The ability to bridge those things together is an underrated skill that we need more of. And everybody here has the capacity to do that. And what you bring to your clients is a big deal. What we would be able to bring into the regulatory space if we have in particular lawyers who also understand the technology piece is immense. With that, I think that makes my welcome and I will stop.
Thank you so much. Questions? Yes.
Thank you, Nicole. This is great and it is super informative. I really enjoyed the presentation. So I have a few thoughts. The first, I want to double down a bit on Professor Rosenblatt's question. I'll say, do you think robo-investors should exist?
Yes.
Do you think that, I mean, I understand that you cannot impose a fiduciary duty on them. Do you think they can preserve a fiduciary duty or just no? So that's question one. Second, disclosure. Do you think that's really the problem with Main Street investors? Do you think it's a lack of disclosure? So is that the issue with robo-advisor? Say we had infinite mythical disclosure. Does that really solve the problem you're describing? And then related to that, so the proposal that you're advocating for, which is a database learned disclosure. So I'm going to refer back to the question you asked Joey, issues of bias.
Yeah.
How would you navigate?
Okay, so first question, should robos exist? Yes. Can they adhere to a fiduciary duty? I don't know. I think how they are operating now, the answer is yes, because there's a human, there's always a human. And under the financial regulatory framework, someone's got to be responsible for supervising and ensuring that the robo-advisor is living up to its fiduciary duty. So in that sense, we go back to Eric, it's a tool. Right? The tool is overseen by a human, the firm itself or the owner of the tool is the fiduciary. Disclosure, is perfect disclosure possible? No. Will disclosure solve all of our problems? No, it won't at all solve all of our problems. The idea of, I love that in a perfect world, disclosure is like, information, perfectly expectant. It takes us away from a caveat emptor world. But does it? Even if I have all the information, it's still making, buyer beware, everything, but still caveat emptor. Finally, bias. I think what's interesting about robos, and I think Ben is going to talk about robos and weird stuff that they're doing, right? Is that your topic? As we chatted. Maybe Ben can talk a little bit more about bias. But what I think about bias in robos is that robos are surprisingly, robo-advisors in the investment space are surprisingly conservative. There have been studies, I don't know how recent they are anymore, that have shown that actually robo-advisor returns are less than returns in some index funds, because if they go too out there, they're afraid of the litigation risk that Eric talked about.
You other questions? Yes.
I have a question. Great presentation. I enjoyed it tremendously. Intrigued by your idea of active and iterative disclosure. Coming from a regulatory background as well, disclosure to me has always served two purposes. One is to provide information to the investor, but also to bind the issuer to a state and to have a verifiable set of information details that you can rely on in case of a subsequent misrepresentation claim, what have you. So I'm concerned, I want to understand better where that iterative disclosure come from. Do you foresee that still being rooted in the traditional voluminous disclosure by obfuscation that we see with, the corporate filings and whatnot? Or do you see some other basis for grabbing that information from and then translating it, piecemeal as needed or desired towards the investor?
Yeah, to the first question, how do I see this being provided? And that's a difficult bit. Conceptually, the same quality of information should be provided. The framework and format of that information is what I think is more important if we're going to stick in the framework that we are in. So some type of translation of pre-existing requirements into understandable format for the individual who is before that particular advisor.
Great, thank you. And we're at time, but we can have one more question very quickly.
Sure. Yeah.
Because I know Ben is going to add so much more on this. I'd love to come back to it at the end if we have time. Is that okay?
Yes.
Thank you.
All right. So thank you very much, Professor Iana Roan. Next, we are turning to Benjamin Edwards. Benjamin Edwards joined the faculty of the William S. Boyd School of Law in 2017. He researches and writes about business and securities law, corporate governance, arbitration, and consumer protection. Prior to teaching, Professor Edwards practiced as a securities litigator in New York office of Skadden, Arps, Slate, Meagher, and Floam LLP. At Skadden, he represented clients in complex civil litigation, including securities class actions arising out of the Madoff Ponzi scheme and litigation arising out of the 2008 financial crisis. His writing has appeared in the Northwestern University Law Review, Washington and Lee Law Review, University of California Davis Law Review, Georgia State Law Review, William and Mary Review Online, Virginia Law and Business Law Review, Michigan Business and Entrepreneurial Law Review, Journal of Business and Securities Law, Virginia Journal of Social Policy and the Law, Investment News, Wall Street Journal, Salon, The Hill, The Washington Post, Bloomberg View, Oxford Business Law Blog, Columbia Blue Sky Blog, and the Daily Beast. He also writes regularly for Business Law Professor blog. Professor Edwards earned his law degree from Columbia Law School and clerked for Judge Samuel H. Mays, Jr. of the U.S. District Court of the Western District of Tennessee. Professor Edwards' most recent publications and working papers may be found on the Social Science Research Network. Professor Edwards, thank you.
Okay, wonderful. Can just because I can't see the room, can everyone hear me? And can you see the slides I have up?
Yes.
Excellent. Okay, so as Nicole mentioned, I'm going to talk about some weird stuff. But first, I want to just let everyone know, thank you so much for putting this on. And I'm sad I cannot be there in person. I was teaching a class late last night, and with the time change, it just wasn't going to work for me to get there. But you're also very fortunate, to be in Ohio. It's a state that matters for securities regulation. You have a very skilled and significant state securities regulator that does merit regulation and is generally a leader among state securities regulators. So if you are in Ohio or practicing in Ohio, you should know that you have a very competent state securities regulator with a great reputation. Okay, so as Nicole mentioned, I'm going to talk about weird stuff. And so I've sort of grouped this into a series of different buckets, algorithmic risks, legal ethics, scams and frauds, and cross-selling. And there's lots of interactions here where AI is going to play, some, significant role. And I think it's worth thinking about more and more as we go through this. So turning, first, to algorithmic risks, what I really mean by this is, if you have artificial intelligence or these other programs that are being used as tools, those tools themselves are going to carry with them particular risks. that may affect both individuals and markets. So with that, it's always easier to understand this with a more specific example. So Rory Van Loo is another law professor who coined this term hyperswitching. And he did it years ago when thinking about a new AI future. This is around the dawn of Siri on your iPhone. So an easy question is, well, what happens if everyone gets an automated digital assistant and you say, please make sure that my savings account is always getting the highest available interest rate from online banking. That sounds great. And everyone would surely love to get a little bit more money and have an AI assistant handle some of those annoying details about moving funds from place to place and investigating this and monitoring this constantly. So what if, one bank moves its, interest rate on its savings up just 0.2% higher than other banks? If lots and lots of people have set up automated switching or something like this, assets are going to move incredibly rapidly. And so if this is happening, at once, in a blink, it's going to have real big effects on how banks are going to need to operate. So if you're used to the money that's in your savings accounts as a bank, you're being somewhat sticky, and if you've paid a high rate and you've accumulated a lot of depositors, if another bank suddenly slips ahead of you by a small margin, you could see a huge hit in terms of how much money is going to immediately run out the door. And it's going to happen in a very coordinated and very quick way. So what do you do if you're a bank? Maybe you fail. Maybe you change the way you operate. So you're just going to need to hold more cash on hand to meet these requests. I don't necessarily have the answer here, but what I want to highlight is that AI being more involved makes it possible for much more coordinated behavior or simultaneous behavior happening at a much more rapid speed than you would have otherwise. What if we turn, from banking then back over to securities? You run into similar sets of algorithmic risks, and we've seen versions of this or bits of this with automated trading, in the past, where if automated trading and causes widespread selling at the same time. If one algorithm triggers a sale and another algorithm's going to react to that and sell itself, you end up with things like the flash crashes that we had in the past. The SEC has tried to deal with some of this by putting in market circuit breakers and other things designed to slow down or stop trading. But I think we're at a time where there's just going to be a lot more risks or differences or a new environment that we may not necessarily understand immediately. It could be even something much more subtle, that particular kinds of assets may get dragged along and overpriced or underpriced in particular ways. And so how this is all going to affect market valuations is something I think we have to always continue to watch. But one of the other things I think we have to also be thinking about is what's really going on with AI and investment advice. One of the major boundaries between when brokerage firms are going to have liability and when they're not is if they're giving you advice. And so sometimes brokerage firms might do things that will not be deemed advice legally, but they're doing them not necessarily because they really want to help you or educate you. Rather, it's because they want to get you to do particular things. So what I'm thinking about here is a lot of online brokerages. You probably have some of these apps on your phone where they're going to make more money if you do particular things versus if you do other things. So generally, you'd say, if you trade stock, and they're getting payment for order flow by routing your order, to someone else, they're going to make, some bit of money if you're trading stocks, and that's good for them. But what's better is if you're trading options and you're buying and you're selling options, they're going to make even more money off the options. And the options are great, but what's really good is if you're trading crypto, because the margins on payment for order flow are the highest, for crypto. So how do you get, a bunch of, people who are, just using their own phones and their own apps to make trades that benefit you? So one option might be to provide them with some education that's not really designed to make them an expert so much as it is to, instill a little bit of overconfidence and get them to do some options trading and really try it out. And so a lot of times you'll see things like that. But what I'm concerned about is when you add, AI to the mix, you can sort of aim that AI at hacking humans. We are ultimately, made of excitable flesh. We respond to images, to sounds, in somewhat predictable ways. So you could use AI to systematically test and refine whatever kind of user interface you're presenting to people using your platform, and determine, what makes them engage in the behaviors that are more profitable. So you want them to do this, and you're sending them messages that are designed, or stimuli that are designed to specifically induce these kinds of behaviors. However, as it stands right now legally, there's questions about whether using AI in this kind of way would be deemed advice. So the SEC in the prior administration was looking at predictive data analytics and trying to figure out how to move forward here, and never ultimately did. And I don't expect anything really happening in the near term. The risks as access to data goes and it grows and AI grows in sophistication is that it might be pretty easy to personalize the user interface for each user. So instead of experimenting on your user base as a whole, you can then start segmenting. Well, these are the kinds of things that get boomers to buy options. These are the kinds of things that get other demographic groups to do things. And so you can see how AI could be used to do all of these things at scale, which just wouldn't be possible if you were doing it by yourself as a human. But at the same time, robo-advice firms, in my view, are a tremendous boon. Betterment, Wealthfront, some of these other major players provide high quality asset allocation. They help people make decisions. They provide access to other financial products, capital, all at a very reasonable cost. And generally, the actual advice they're providing in terms of how they recommend and shift people's portfolio allocations is substantially superior to commission-driven advice. There was an audit study about a decade ago where investigators sent regular human beings with fake portfolios into stockbroker offices to ask them what they should do with their portfolios. And they would come in with pretty good, well-diversified portfolios, and they would come out with portfolios that were not as good, but that were invested more in products that pay the advisors commissions. And so the challenge here is, how do you balance all this? Ultimately, as things have played out so far, generally Betterment and Wealthfront are providing pretty high quality asset allocation advice to their users. This, of course, doesn't mean those services or firms are perfect, but in my view, they tend to beat a lot of the alternatives. Okay, so turning to what else is next? What do we do? So if you've got a big pool of investable assets, and you've got a lot of different people that use it, if you're making money off of your investment advice and your management fees, maybe you're charging 0.25%, if you're Betterment, those management fees are great, but if you want to make more money, and of course we always do want to make more money, you have to start thinking then about what do you do next? What else do you try to sell them? And so the cross-selling opportunities here are pretty significant. Maybe that people who have a lot of investable assets, they could probably also use trust and estate services. They've got money, they've got wealth. That's something they should protect. So perhaps they need insurance or other more creative investments or other things. You just have so many opportunities to potentially turn and sell other things to these populations. It's a mixed bag. Sometimes these other opportunities to sell things to these people will really benefit them and help them. Trust and estate services is probably a net good as long as they're paying a reasonable price. Getting insurance is probably good. The question then is, well, how much should they be doing, or really what boundaries do we want to think about placing on it? So one of the things I want to highlight is that we are now seeing a move to scale up these other services, through, venture-backed startups. I want to just highlight, one here, very quickly. Get Dynasty is a firm that is aiming to make it possible for everyone to just go ahead and create, a trust and put their assets into a trust. They basically give the trusts away because they can create them at scale and very easily. And they'll sell, some management services. You can hire them as a successor trustee. They'll provide you, other, services to go with this. But, ultimately what you're really looking at is, you had robo advice, in the, stocks and bond space, and now you're beginning to see, variations of that, begin to move into other fields. This is also a significant opportunity for legal tech startups. Trust and Will just raised, I think, $25 million from Northwestern Mutual. And what they're aiming to do is to use AI to really simplify, estate planning. And this is ultimately, generally probably good as far as this goes. However, when you're a lawyer and you're providing these kinds of services and you're providing legal advice, there are going to be, issues around this. So if you're providing these kinds of services and, your clients are using them, then you're going to have to also make sure that you're complying with the ethics rules and you're advising them in writing about the desirability of, whether or not to follow, that advice, or, you make sure you give them a reasonable opportunity to seek the advice of independent legal counsel. There are also ownership challenges with a lot of these entities because lawyers, if the entity is doing the practice of law, lawyers are not generally supposed to share ownership of that entity with anyone who is not a lawyer. So you may be able to solve some of these problems just by segmenting out, what portion of it is providing the investment advice. So turning to, other possibilities, AI might also be used, in this space to be a more effective, guardian than your usual flesh and blood advisors. And so what I'm concerned about here is that there's just an enormous volume of scams and frauds happening, today. Everyone has probably gotten these weird text messages about some speeding ticket in Massachusetts, which, makes no sense to you because you've never been there, or somebody who is accidentally texting the wrong person. We're all deluged with these contacts all the time now. And what it really is just a huge international scam apparatus constantly putting out feelers to find people they can talk to, manipulate, and ultimately convince to part with their money. So in 2022, it was, somewhere in the neighborhood of 8.8 billion as far as the FTC knew. 2023, it was 10 billion from the FTC data. FTC is probably wrong here. Most people, or a lot of people who get scammed in this way, don't report it. And so the true number is probably somewhere in the neighborhood of, I would guess, 40 to 60 billion. The AARP has estimates that are consistent with that. It is hard to really know just how much of this is happening, but it is happening at scale right now. It's often enabled by artificial intelligence and accelerated by artificial intelligence. So if you've got a scammer who is working someone and they get asked a question that the scammer doesn't know, they can use AI very quickly to come up with a plausible sounding response. And so they might be able to maintain credibility for longer than they would have otherwise. I know I've personally been contacted by at least like 4 or 5 people fraudulently claiming that they are employed by Goldman Sachs. It just happens constantly. So one of the challenges is, what role should wealth management here play in, some kind of, fraud interdiction? Scammers are convincing people to dissipate their assets, and, stealing that money, is what they do. But, wealth management professionals probably should have some role in making sure that clients don't fall for these kinds of scams. The wealth management professionals themselves are not stealing the money, but at the same time, oftentimes their clients are coming to them and asking to pull their money out because they're being scammed, but they're not getting the warnings they need. So in this context, a lot of financial advisors are fiduciaries, and you're trying to figure out when should they have liability. You have to look at, what would a fiduciary do, and is it going to make a difference? AI assistance here could be, really important. One way to think about this is, sort of AI using a human in the loop, or your financial advisor might have AI whispering in their ear when they meet with you, when they talk to you about what to follow up on, what to ask more questions about, what raises a red flag. So right now, I tend to think about this by breaking, fiduciaries into, different buckets. A real fiduciary, when there's some kind of problem, is going to force those conversations and do what's necessary to slow down the process to protect a client. Where a more feckless fiduciary is just going to be facilitating requested transactions and assuming the client knows, what they're doing. The worry is that there are often a lot of red flags that, the financial advisor, the human, may not notice or may not react to as quickly as they should. So AI, I think, has real potential here for helping people begin to respond and react to these in some more meaningful way. And so my hope is that AI can significantly shift, how we operate, and AI won't just be deployed, by the scammers looking to rip money out of retirement accounts, but also can be deployed to detect this action and defend against it. So with that, I want to say, thank you, and I'm happy to take questions and keep the conversation going.
Thank you, Professor Edwards. Your questions. Yes.
Going back to your scenario where your husband had to sign something, I wonder if an electronic or robo-advisor would ever invoke the 11th commandment of real estate developers. Of course, you're familiar with the 10 Commandments in Charlton Heston from religious training. So the 11th commandment, it should never be violated, or bad things will happen on a big scale. You won't get turned into a pillar of salt, but maybe something worse in this life. Well, it's a simple rule. Thou shalt not sign personally. So if you're going to do, let's say, Fountain Square Development in Indianapolis, the late 80s, and your name is Galbraith, you don't sign to the development because it swelled up to $175 million, far beyond what they originally thought. And they said, well, you got to pay the rest of this. And he lost a lot of houses and a ranch and a lot of money. Would a robo-advisor just say the equivalent of thou shalt not sign to buy this security or certificate of deposit, stock, etc.? Personally.
Yeah, I don't know, and I think it's a good segue into Ben's thoughts on the difference between functional and feckless fiduciaries, right? Having a functional robo-advisor fiduciary would say, would tell you what the risks are and say, okay, like, here's all the risks. I have made sure that you understand them, or you've told me you don't care and to stop talking, and you're doing this on your own, warning, warning, warning. Where a feckless robo-advisor, same problem as we have with humans, would say, okay, yeah, do it. Or not. So yeah, I think it can depend, and it's also going to depend on the inputs that we put into it. What are the parameters that we train the robo on to a soft question about bias? What do they know? What do they not know? And how individualized or specific is their advice going to be?
Thank you. Other questions? All right, well, that's actually perfect because we are at time. So, thank you so much again, Professor Edwards, for joining us virtually. It was truly a pleasure, and we were happy to have you.
Thank you. Have fun.
So I think we now have time for a brief break. So please return in 15 minutes for the remainder of the symposium. Thank you.